so I will call the meeting to order. There is a quorum present. Obviously, Commissioner Wilkins and I are here in person, but Commissioner Weatherall is also joining via Zoom. And normally we do a flag salute, but given that we're trying to avoid spewing stuff out into the atmosphere, I think we will skip that until COVID is not an issue for us. So let's go into 2.0, which is additions and revisions to the agenda. Do you have any?
I do not.
Sherry doesn't. Leslie, do you have any?
I do not.
So we'll go into 3.0, which is correspondence and public comment. I don't have any correspondence under public comment. Individuals wishing to address the county court may do so at this time and at other times throughout the meeting. Speakers are asked to raise your hand to be recognized by the chair. Give your name and address and limit comments to 3 minutes. So for those who are here to talk about the hearing, we'll do that during the actual hearing. So this is for other business before the court. Does anybody have any public comment? I don't see any, so we'll go right into consent agenda.
I have lost my connection here. And I totally don't have a connection, so I'm not on Zoom.
Okay, that's fine.
Okay.
I'm just doing it so I can see Leslie.
Okay. Well, I wanted to see Commissioner Weatherall also, but I couldn't get into the web, so.
She's definitely there.
Okay,
Trust
I
me.
believe you. I hear her voice. I just thought maybe those others who might be on there might want to see what we were doing as well. Commissioner Weatherall, did you have any questions about the consent agenda?
No, I did not.
I move to approve the consent agenda.
Second.
It's been moved and seconded that we approve the consent agenda, which consists of consider approval of July 1st regular meeting minutes, consider appointment of Commissioner Wilkins to OSU and Citizens Advisory Committee, consider approval of amendment number 4 to ODOT grant agreement number 32393, consider approval of State of Oregon intergovernmental pass-through grant agreement number 165272, consider approval of Arlington TV Cooperative Loan Promissory Note Amendment and Trust Deed Addendum, consider approval of Drive-In Loan Promissory Note Amendment and Trust Deed Addendum, and consider approval of Pat's Pheasant Grill Loan Promissory Note Amendment and Trust Deed Addendum. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, so let me just catch up in my packet here. And we are 2 minutes ahead of schedule, so we're just going to pause, take a beat for a minute, and then we'll open up the hearing here in 2 minutes so that we're on time for folks who may still want to log in. I will say for folks just who are on Zoom, this is new for us to do a land use planning hearing over Zoom. So we're hoping if you guys have comments, obviously we'll get to that later in the hearing, but if you called in to unmute yourself, you need to push dial *6 and that will unmute yourself. If you logged in online, there's a little, if you go to the bottom of your screen, you can actually, I'm trying to figure out where you raise your hand at. You click on the participants, right? And then you can click your hand, and then you can, is that right?
I can see it.
So if you guys could, Lisa is kind of keeping track of folks who, and she's the co-host of the Zoom. And so if you would like to make a comment, there's usually a hand raising function on here, but I don't see it. So if you could even just shoot Lisa just a little note in the chat thing to let her know if you're opposed, in favor of, or neutral. And she'll just keep track of those folks who are wanting to testify via the online option. We have folks that are in the room as well who have signed up to testify. And given we're trying to sort of coordinate both, we'll be a little bit flexible in allowing folks who are trying to figure out how to work the Zoom platform at home. All right, so it is 10:05. So we will move into public hearing to consider modifications of conditions of approval for a conditional use permit issued to Waste Management Disposal Services for a solid waste landfill known as Columbia Ridge Landfill and Recycle Center in the exclusive farm use zone. Today's proceeding is a quasi judicial public hearing. This is the time duly set and advertised for a public hearing in the matter to consider modification of conditions of approval for a conditional use permit issued to Waste Management Disposal Services for a solid waste landfill known as Columbia Ridge Landfill and Recycle Center in the exclusive farm use zone. The hearing is now called to order. The public hearing will be conducted as follows. Staff will give their report and answer any questions from the county court. Following the staff report, the applicant will have time to present to the county court. I will then open the hearing for public testimony, proponent, opponent, and neutral. After the opportunity for public testimony, the county court may have additional questions for staff. The applicant, Waste Management, will have an opportunity for last rebuttal. The county court will then decide whether to close the hearing and deliberate the matter. Under rules for testimony, when you testify, please state your name and address for the record. Please keep your testimony concise and relevant to the issues before us this morning. All testimony shall be directed towards the county court and not towards other members in the audience. Given the amount of people we have, I'm thinking if we could try to limit to maybe 3 to 5 minutes for the public comments, because I'm assuming we'll have more people signing on. That would be great. The applicable criteria are listed in the staff report. These are the criteria the county court will use to make its decision. If you believe there are additional applicable approval criteria, please identify such criteria when providing your testimony. Failure to raise an issue with sufficient specificity to afford the county court and all parties an opportunity to respond to an issue may preclude an appeal to the Land Use Board of Appeals based on that issue, and may preclude an action in circuit court. Failure of the applicant to raise constitutional or other issues relating to conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. There are some additional rules and procedures for this hearing. They are as follows. Let me see here. The hearing is being recorded. Obviously, we're on Zoom. The order of proceedings, as I said before, we'll do this introduction. There's a staff report, the applicant presentation, testimony in support, testimony in opposition, neutral testimony. Then we'll have staff comments, the applicant rebuttal, and then deliberations. The applicant is generally provided a half hour for their presentation. Other participants are generally afforded 10 minutes. We can probably do up to that. However, the county court may limit the amount of time afforded for testimony depending on the number of parties that desire to present oral testimony. So we're just kind of watching to see if we have a lot of people that start raising their hands. I think we'll try to limit it to 5 so that we can get through everybody. Testimony should address the applicable approval criteria listed in the notice of the hearing, will be presented in the staff report. If you believe there are additional approval criteria, please clearly identify the omitted approval criteria that you believe is applicable. Please avoid repetitive or redundant testimony and testimony that is not relevant to the issue's applicable approval criteria. It's encouraged that you simply indicate that you agree with another party instead of restating the points already made by other parties. Please refrain from demonstrations in support of the speaker. No clapping, cheering, jeering will be allowed. We ask that you be courteous and orderly in this hearing. Any parties may request the record to be kept open for a minimum of 7 days following the hearing. The applicant will be entitled to a final rebuttal period following any extended record period. To preserve your right to appeal to the Land Use Board of Appeals, you must state the issue clearly and with enough detail for the hearing's body and other parties to address the issue, raise it or waive it. Failure of an applicant to raise constitutional or other issues related to proposed conditions of approval with specific detail enough to allow the county to respond to the issue precludes an action for damages in the circuit court. All persons testifying must be recognized by the chairman. Do not attempt to speak from the audience, and especially with our little Houdini guy over here, we'll be asking folks to actually come up to the table so that the camera and the audio will pick you up. To expedite the hearing, the court members may ask questions of persons as they testify. So at this time, I would ask the members of the county court to disclose any ex parte contacts, biases, or conflicts of interest a member may have pertaining to Waste Management's conditional use permit. If so, please indicate the nature of the ex parte contact, bias, or conflict of interest, and indicate whether you intend to participate in or abstain from the hearing. Does any commissioner have a conflict of interest that they wish to declare?
I need to declare a conflict.
Go ahead, Leslie.
Because my husband is an employee of Waste Management, I will refrain from further participation in accordance with ORS 244.120.
Okay. Sherry, any conflicts to disclose? I have no conflicts either. Does any commissioner have any ex parte pre-hearing contacts to declare? Me either. Does any commissioner have any bias in this matter? Me either. Is there any other reason a commissioner does not believe they can participate in these proceedings? Me either. Does anyone in the audience wish to challenge the ability of any member of the court to participate in these proceedings? I'm looking online too. Again, folks, if you're dialing in and you need to unmute, you just hit *6. I do not see any. So we will move in to staff report and questions. Staff will now present the staff report and any correspondence on this matter, other than those items already included in the record. Go ahead, Michelle.
Okay, good morning.
Good morning.
All right. Today, before the county court, we are here to consider a modification of conditions of approval for Waste Management Disposal Services of Oregon Solid Waste Landfill Conditional Use Permit. The applicable criteria for this proposal is the modifications of conditions of approval of conditional use permit issued to Waste Management Disposable Services for solid waste landfill known as Columbia Ridge Landfill and Recycling Center in the exclusive farm use zone. The property subject to the conditional use permit is described as Township 2 North, Range 21 East, Sections 20, 29, 30, and portions of 31 and 32. And there's a contiguous 8.4 acres located in 2 North, 21 East, Southeast quarter of Section 17. The applicable criteria are found in the Gillum County Zoning and Land Development Ordinance in Article 7, Section 7.010A4, procedures for reviewing and altering a conditional use permits, and Section 7.020KR, standards for governing conditional uses, and Article 11, Section 11.160B, modification of conditions of approval. Following the 2019 review by the Planning Commission and the County Court, Waste Management desires to modify and clarify several of the conditions of approval governing its conditional use permit. And I'd just like to restate, in 2019, Gillum County Court did deem Waste Management in substantial compliance with their conditional use permit, and that was part of their periodic review that was conducted. And today we are focusing on proposed modifications to the actual conditions of approval. The legal notice was done and published on July 9th, 2020 and July 16th, 2020 in the Times Journal, a weekly newspaper of general distribution in Gillum County and the surrounding areas. Prior approvals listed. For those that are on Zoom and are participating, all of these materials were posted on the Gillum County website last week, and you can still find them on the website. So if anyone's following along, you can pull up those materials as well. And that would be under the county court's meeting packet. Okay, I'm not going to list all the prior approvals, but I'm just going to state this all started back in 1987 when Waste Management came to Gillum County for their original conditional use permit. There have been subsequent reviews, periodic reviews, and additional modifications to the conditional use that leads us to today, 2020. So when we're reviewing the applicable criteria, the below findings are noted. In section 7.010, authorization to grant or deny conditional uses, we get to condition Or number 4, procedures for reviewing and altering conditional use permits. And we go to F, which is planning commission makes one of the following decisions. And the findings is this section sets out the provisions of altering a conditional use approval, which staff finds applicable to a request to modify conditions of approval to a conditional use permit. The procedures set forth in this subsection have been adhered to for these proceedings pursuant to Article 11, Section 11.160B, Conditions of Approval of the Gillum County Zoning and Land Development Ordinance. Ultimate authority to modify a condition of approval is vested in the review authority that imposed the condition. Accordingly, the Gillum County Court, as the review authority that approved the 2012 conditions of approval, will make the final determination whether to modify any of the conditions of approval today. The purpose of these proceedings is for the county court to review and make a decision as to whether or not the conditions of approval will be modified. The next applicable criteria is in section 7.020, standards governing conditional uses. And we go to K, solid waste disposable facility, and then we go to number 3, the facility shall be conditioned upon the applicant obtaining a solid waste disposal permit from the Oregon Department of Environmental Quality in compliance with the conditions of that permit and with permit and requirements of any other regulating agency. Findings. The staff finds that the county court has discretion whether to modify any existing conditions of approval, subject only to the compliance with approval criteria outlined in the staff report, including the foregoing subsection. Staff finds that the conditions of approval, as proposed to be modified, do not affect the foregoing requirements of a solid waste disposable site. Because there are adequate screening and buffering requirements, there will be no material interference with any accepted farming practices on adjacent lands. Staff notes that Waste Management owns all of the land abutting the solid waste disposable site. No modification to the requirement to obtain and maintain appropriate DEQ permitting is proposed as part of this application. We further move down to letter R, use of existing solid waste rail unloading facility for hazardous waste, and we go to number 4, that facility shall unload, load, store, and transport solid, hazardous, and other waste in the manner required by federal and state law. Findings. Staff finds that the conditions of approval, as proposed to be modified, do not affect the foregoing requirements of a solid waste disposable site that transports hazardous waste by rail. There are no proposed modifications to the screening or buffering requirements of the site. Because there are adequate screening and buffering requirements, there will be no material interference with the accepted farm practices on adjacent lands. Staff knows that Waste Management owns all of the land abutting the disposable site. No modification to the requirement to comply with applicable law is proposed as part of this application. Then we move to the applicable criteria in Article 11, Administrative Provisions. And we go to section 11.160, conditions of approval. Number B, modification of conditions. At an applicant's request, the review authority, which made the decision on the application, may modify or amend one or more conditions of approval. The request shall be processed as a separate land use application with proper notice and hearing and be subject to a separate fee. Finding, as addressed above, this section vests the county court with ultimate authority to modify any of the conditions of approval as the county court imposed the 2012 conditions of approval. The application will be subject to public hearings before the Planning Commission and county court that will be held in accordance with the requirements of Article 11. For those that are following along, hopefully this is accurate as what was posted on the website. I'm on page 7, and this would have been under the materials for the public hearing for the county courts. And page 7 is titled Conditions of Approval. Conditions of Approval, the overview here. This section sets out the current 2012 conditions of approval in numerical order. For each existing condition of approval, there is a discussion of the purpose of the condition of approval, any changes proposed by Waste Management, any recommendations of staff, and finally options for the review authority. The current 2012 condition of approval is shown in bold below. Are we all good so far?
Yeah,
Okay.
you're doing great.
Just thought I'd just do a check, make sure. Okay. Yes. So the first condition is condition number 1. And I will start with pointing out, again, if you're following along on the documents, the bold is what is currently the condition that was approved in 2012. None of the conditions have been altered since 2012. So that is our baseline mark, is the 2012 language for the conditions of approval. Condition number 1, I'm just going to summarize. It refers to a regular interval review of the conditional use permit that has been set forth as a 5-year review. This review language, the review or regularly scheduled check-in is critical in keeping all parties accountable for activities and changes affecting the landfill operations. The wording of the condition currently requires Waste Management to initiate a review, which is ultimately made by the county court after recommendation by the Planning Commission. Public hearings are held before both the Planning Commission and the county court as part of this review process. Such reviews have occurred since Waste Management received initial authorization for conditional use in 1987. Because these reviews are intended to determine whether the landfill is operating under existing conditions of approval and at a scope, nature, and scale previously reviewed and approved, the county may consider a more administrative review type. More specifically, this would only require public hearings if there is a proposal to modify either the operations of the facility or any previously approved condition of approval. Condition number 1 also requires that the Columbia Ridge Landfill and Recycling Center Citizen Advisory Committee prepare a report on whether Waste Management has satisfied certain established certain criteria established in the condition number 1. In practice, this is difficult to achieve as the Citizens Advisory Committee, as a body comprised of citizens, generally does not have the time, resources, or technical expertise to prepare such a report. Given that the reviews are subject to public hearings, the Citizens Advisory Committee could simply provide testimony on the review instead of preparing a specialized report. Staff recommends an amended version of the condition number 1, whereas the review and final decision is conducted through a public hearing at the Planning Commission level. The county court, or the Gillum County Zoning and Land Development Ordinance allows for the Gillum County Court to call up a decision of the planning director or planning commission at any time prior to the expiration of the appeal period for Article 11, Section 11.120. Staff commented that the Planning Commission only review. Staff's recommendation is the Planning Commission review this moving forward, and that it better aligns with the review process with the Zoning and Land Development Ordinance, and still offers the county court an option to participate if they choose. So the option that went before the Planning Commission and with at their hearing was to recommend to the county court that the reviews still happen on a 5-year interval and that it be conducted and satisfied at the Planning Commission level. I do understand that the county court does have the option to change this and still maintain that the review authority be with the county court. This is a recommendation, and when the county court gets to deliberations, the county court can choose to accept that recommendation or make your own decision on this matter. And at this time, the recommendation is to remove the Citizens Advisory Committee report from condition number 1. The conditions in 2012 referred to the Citizens Advisory Committee 3 different times. And so we've consolidated in this process and just referred to the Citizens Advisory Committee only once moving forward. So that is the recommendation for number 1. And I will just point out, Waste Management is in favor of that as well at this time. So Planning Commission, staff, and Waste Management all in favor with the proposal of a continuing 5-year review at the Planning Commission level. Condition number 2 refers to the review time frame, and it's tied to the host fee agreement. And so this condition refers, it's actually a date that needs to change because it references 2016. So there are proposed amendments to this wording. The proposed findings, condition number 2 requires that the renewal of conditional use permit may not be finalized until a new host fee agreement is in place in the year 2016. The Gillum County Court and Waste Management entered into a combined Gillum County host fee and roadway maintenance agreement effective March 1st, 2016 to December 31st, 2025. The host fee and roadway maintenance agreements is of utmost importance to the county. This agreement is negotiated between the Gillum County Court and Waste Management representatives. Although neither the Planning Commission nor the Planning Director are involved in the host fee agreement, a condition of approval requiring the existence of some type of agreement is a necessity, as the county could only require such an agreement in conjunction with a land use approval. Previously, there were two separate conditions of approval to address the host fee agreement and the roadway maintenance agreement. Since these agreements have been combined, it is logical that reference to each should be combined under the conditions of approval. Thereby, the new condition of approval number 2 below incorporates the previous condition number 2, the host fee agreement, and number 8, the road agreement. The modification also makes reference to the parties responsible for the agreement. So I'll point out that the recommendation is number 2 be retitled to host fee and roadway maintenance agreement, and that the Planning Commission and staff and Waste Management at this time all agree in the proposed language for number 2. Condition number 3. Condition number 3 is titled currently, if legislature preempts county authority. Proposed findings. This condition has been unchanged since the original condition of approval. It arose from concerns that legislature could preempt the county from enforcing any condition or requirement material to the county's decision to authorize the landfill use. The Planning Commission previously questioned the need to carry this condition of approval forward, given reference to entering into an agreement with substantially similar benefits to the county, because any such agreement is outside of the preview of the Planning Commission. It should be noted, however, that this condition requires renewing the conditional use approval as an alternative if a separate agreement cannot address the preemption. Because that alternative is land use related, there is a basis to keep this condition, or perhaps with some additional clarity. So there is an amendment proposed to the language of number 3. Waste Management, Gillum County Planning Commission, and the county court are all in favor of the proposed language being amended, and to change the title for number 3 to move forward to just call it preemption. Condition number 4 refers to buffer. And since this is very short, I'll just read what the current condition says. It says, buffer, the applicant will maintain an adequate buffer area as described in the 1987 application. The proposed findings. A buffer is a requirement of the conditional use permit. The lack of specificity in this condition on the location, size, characteristics, and permitted uses within the buffer is a concern. The county and Waste Management agreed that these issues need to be resolved. The findings to the 1987 conditional use permit state that approximately 700 acres of the 2,000 acres will be developed for an active landfill operations, and the balance will be used for a buffer area, as well as for the sites of the unloading facilities and support facilities. In 1987, findings further note that a minimum 150-foot wide buffer area will be provided between the limit of the refuge fill area and the property boundary. Agricultural uses, drainage, and monitoring facilities, and a perimeter access road were identified as allowable uses within the buffer. Subsequent to 1987 conditional use permit, a number of improvements and accessory uses have been added to the site that were not specifically contemplated in the buffering requirements. Specifically, there is now an administrative maintenance building, gatehouse, public drop-off area, rail yard, energy production facilities, and overburn stockpile areas. Most of these improvements, accessory uses, should be subject to a buffer. Another changed circumstance is that Waste Management has acquired additional land adjacent to the project property subject to the conditional use permit. Although these lands create additional distance from other landowners, the buffer should be entirely satisfied on the land subject to the conditional use permit, as those adjoining lands could be sold in the future. The Planning Commission discussed the buffer requirement. It was agreed that a buffer must be applied to all operational areas. Defining operational areas was discussed. The Planning Commission's consensus was to incorporate a definition for operations so that when those uses are identified, a minimum buffer of 150 feet shall be applied. So at this time, there is proposed amended language to this condition regarding buffer. And it does provide that there will still be a minimum of 150 feet, and it does provide a definition for operations. So the focus on the buffer is, again, to identify operations in which Waste Management is conducting their operations related to solid waste landfill, and then the buffer would be applied to those areas. And Waste Management, Gillum County staff, along with Planning Commission, all are in favor of the proposed amendment for changing the wording for the buffer condition at this time.
Any questions so far, Jerry?
I have some, but I'll wait
Until the end?
Okay.
Okay. I just thought since Michelle's taking
until a breath.
Yeah.
So condition number 5 is currently titled expansion. The Gillum County Assessor is to be notified at any time a relevant change in use occurs beyond the original 520 acres, currently disqualified from farm use deferral. Proposed finding is in 1987, there was a request for a partition of exclusive farm use land to create the approximate 2,000 acres on which a solid waste landfill was to be established. The application in 1987 described that Waste Management was approved to purchase an estimated 2,000 acres, of which an estimated 700 acres was to be developed in an active landfill. Staff understands the reference to the 700 acres is lands to be disqualified from special farm assessment. This condition of approval lacks clarity as to what acreage must be disqualified and when such disqualification should occur. It has also created compliance challenges as the location of disqualified acres has not been consistently documented. Because of operations associated with the activities are non-farm in nature, staff recommends that any areas where operations occur, except for permitted uses within the buffer area, be required to be disqualified. Annually, the applicant should provide a site plan showing active operational areas on the subject property. Additional disqualifications must occur prior to expanding any operational area. Although neither the Planning Commission nor the Planning Director are involved in the act of disqualifying acreage from farm tax deferral, a condition of approval requiring regular assessment and accountability of such acres is a necessity, as any time exclusive farm use is no longer used for its intended purpose, there are measures to be taken. Previously, the Planning Commission recommended to eliminate this condition. However, since the Gillum County Assessor and County Council have both weighed in favor of keeping, although amend the language. The Planning Commission recognized the connection between the operational areas and disqualification for farm deferral, but found it should be up to the assessor to determine whether to disqualify. The requirement to establish a baseline by the production of Exhibit A and the requirement to annually update this map should be helpful to the assessor in determining any disqualification. It was consensus after lengthy discussion to recommend the staff proposed amended language for this condition minus the last sentence, which refers to a mapping on Exhibit A. However, if the condition is eliminated by the Gillum County Court, the Planning Commission would not object. So at this time, if the county court elects to continue with this type of condition, it would be to be retitled and call it disqualification. The Planning Commission at this time is proposing amended language. Further discussion with legal counsel after the Planning Commission hearing is to staff's recommendation, which differs now from Planning Commission, would be that we just eliminate this condition. It really is a function of the assessor's office, and it just makes more sense at this moment in time for the assessor to track that and not for the Planning Commission or the Planning Director to get involved in those particulars. So that's where a difference does occur right now with the recommendation. Planning Commission did amend and is proposing amended language. And staff at this time would say, go ahead and delete that condition of approval. And I believe Waste Management would probably, they'll have time to comment, but I believe at this time they could go either direction, keep or stay. And you'll hear from Waste Management on that later. Condition number 6, which is currently titled Local Services and Vendors. Applicant will make best efforts to utilize the services of and purchase supplies and equipment from local vendors. Proposed findings. The Planning Commission has previously questioned this condition given that it does not concern land use. This condition is a matter of county policy directed by the county court. This condition is not currently in the host fee and road maintenance agreement, where the Planning Commission feels it is better suited for. If the county court is inclined to keep this condition of approval, guidance for compliance is requested. At this time, all parties, Waste Management, Gillum County staff, and Planning Commission are recommending that this condition be removed from the conditions of approval. Condition number 7, currently titled Landfill Operations. I'm not going to read this condition. It is very lengthy. The current one as of 2012. The proposed findings for this. There is a concern with how to document compliance with operations and what should be monitored. There is a direct correlation with the Department of Environmental Quality permits and county permits for solid waste landfilling. Planning Commission discussed staff proposed amended language at their hearing. Chair McKay offered one suggestion to the staff proposed language at the Planning Commission hearing to insert some different wording, and it was consensus to recommend the staff proposed language with the amended suggestions by the Planning Commission chair to the county court. So at this time, it is, the wording would still be landfill operation. The permittee must obtain and keep current all applicable permits and approvals from the Department of Environmental Quality and other applicable agencies and operate the landfill in accordance with such permits and approvals. And that is the recommendation from Waste Management staff and Planning Commission to amend that condition language. Condition number 8. Currently, the condition says road agreement. As previously stated under condition number 2, the host fee, the road use agreement, and the host fee agreement have been combined and were combined by the Gillum County Court in 2016, working with Waste Management. So the proposal is to eliminate this standalone condition because the proposed is to incorporate it into condition number 2. Condition number 9 is the Citizens Advisory Committee. The proposed findings for condition number 9. The Planning Commission notes the Citizens Advisory Committee has been established per Oregon Administrative Rules 459.320, and the Gillum County Court has appointed members to serve on the committee. This condition refers to reporting requirements of the Citizens Advisory Committee to the county court, which is not a specific requirement of the committee. The Citizens Advisory Committee is also referenced under the condition about communications, number 12. If this condition is kept, the 2 Citizens Advisory Committee related conditions could be combined. The Planning Commission recommends the county court evaluate how the Citizens Advisory Committee functions and who is to be the administrator for carrying out the staffing functions for the Citizens Advisory Committee. The Citizens Advisory Committee is a county court appointed committee, and if given more direction, could be a very useful tool in evaluating activity at the solid waste landfill. The recommendation at this time, as I kind of previously stated, the Citizens Advisory Committee was referred to 3 times under the 2012 conditions. So this condition is being recommended to eliminate this standalone, number 9, and still retain reference to Citizens Advisory Committee under the communications condition, which is number 12. The further recommendation at this time by the Planning Commission is the Planning Commission recommends the county court evaluate how the Citizens Advisory Committee functions and whom is to be their administrator for carrying out the staffing functions of the Citizens Advisory Committee. The Citizens Advisory Committee is a county court appointed committee, and if given more direction, could be a very useful tool in evaluating activity at the solid waste landfill. So the recommendation for number 9, that's supported by Waste Management, Gillum County staff, and Planning Commission, is to eliminate this condition at this time. Condition number 12 is titled Ownership Transfer. This is a very lengthy condition again, and so I'm not going to read it because everyone. Number 10.
Number 10.
Oh, I said 12. Just number 10, sorry. We're on condition number 10. I meant to say the 2012 was titled, there we go, ownership transfer. And it's a very lengthy condition. And so the proposed findings, this condition establishes that the conditional use permit can be reviewed whenever there is a change in ownership. Some may argue that this condition is appropriate because the approvals were crafted to the specific operations and resources of Waste Management. Others may argue that it should not matter who operates the conditional use permit, provided sufficient conditions of approval are in place to regulate the use. For clarity's sake, it could be reduced to simply require a conditional use permit whenever there is a change in ownership, or require a new conditional use permit when there is a change in ownership. There was consensus of the Planning Commission to recommend the staff proposed amended language, which is, and retitle it so it says, transfer of ownership or assignment. This conditional use permit does not run with the land and may not otherwise be assigned or transferred without the prior written consent of the Gillum County Planning Department. So the recommendation at this time with Waste Management after the conclusion of the Planning Commission hearing is Planning Commission, staff, and Waste Management are in favor of recommending the amended language for condition number 10. Condition number 11. So condition number 11 is titled Seattle and Metro Contracts. Proposed findings for this condition. This condition refers to an action that should take place between the Gillum County Court and Waste Management if there are changes in economic circumstances and is thus not necessarily land use related. The Planning Commission recommends eliminating this condition of approval as it is better suited for the host fee agreement. However, such language is not presently included in the host fee agreement. If the county court desires to maintain this consultation obligation, staff recommends keeping this condition until such time as the host fee agreement is amended to include a comparable condition. This is a difference, the recommendation at this time differs between staff and Planning Commission. Planning Commission is recommending that this condition, number 11, be eliminated. And staff would say if the Gillum County Court does think this is a value and a policy concern, and yet the host fee agreement will not be negotiated, or I guess up until it's getting through 2025, then staff recommendation is to keep this as a placeholder currently under the conditions of approval until the time the county court can incorporate it into another document. So this is one that the county court will have to weigh in on the different recommendations.
Is there, on this, the Metro contract was just re-upped. When does the Seattle contract expire? Do you know off the top of your head, Leah?
That Seattle contract is kind of an interesting contract because it doesn't expire, it just keeps getting renewed. There's not really an expiration date on it, so it's just this, it just keeps rolling over. That's how I remember it.
Okay,
So
I would concur with that. Yeah.
okay.
it's not really, there's no, this is the date.
I asked just because it seems like if there are contracts that have been signed with these entities that would go past when the next review period would be, I'm not sure if it's necessary. Yeah. Go ahead.
All valid points for that condition. You bet. You bet. It gives you food for thought. Then we move to condition number 12, which is the communications condition. The proposed findings for this: communications are important, especially with the local governmental agencies affected by the landfill operation. However, this language should be clarified. There were some suggestions during the Planning Commission hearing to refer to actual statute and administrative rules and incorporate those references in the condition. At the conclusion of the Planning Commission hearing, the consensus was to recommend the staff proposed language for amendment with suggested additional amendments, which is to incorporate ORS and administrative rules. And so at this time, the proposed amendment is Waste Management is in favor, staff is in favor, and Planning Commission is in favor. So there's an option there for the county court to consider. Condition number 13 is titled out-of-state waste. The proposed findings for this condition, staff notes that this is allowed and has been allowed for a long time. The condition is not necessary as a condition of approval at this time. A form of this condition is included in the host fee and road maintenance agreement already. The Planning Commission recommends eliminating this condition of approval. This is allowed and the condition is not necessary as a condition of approval. And again, it's in the current host fee and road maintenance agreement. At this time, the Planning Commission, staff, and Waste Management all concur with a recommendation to eliminate this condition.
So was this originally, the history of this was thinking that the legislature may do something that did not allow that waste to come?
Correct,
in? Is
correct.
that what-
There was actually proposed legislation, and I don't know if it was state or federal or a combination, that would have imposed a tariff, a tax for out-of-state waste that came into Oregon, and it could have actually very been detrimental to keeping waste management functioning at Columbia Ridge Landfill, because as we all know, one of the biggest contracts is the Seattle contract waste that comes in, and so that would have made it very difficult. That legislation, I believe that it was fought, and I don't think it ever came to fruition. And again, there is a clause in the host fee agreement regarding this, so it's an allowed. What I remember from doing some research was that one of the outs to try to make sure that legislation could not be adversely impact, this was if there was an already agreement with the jurisdiction that allowed for that out-of-state waste to occur. So if we eliminate from the conditional use, the county court is still protected by having it already in the host fee and road weight maintenance agreement. But again, that's up to the county court to decide if they want to have dual reference, or if you're okay with having that in the host fee.
And then condition 3 anyway, would the preemption would also trip potentially if they went back and tried to do that again. I mean,
Correct.
it would,
Yep.
it would trigger that.
Exactly, the preemption. Yep, could trigger that as well. Condition number 14. Open top containers is what it's titled. Okay, yep. I'm going to try to just summarize this.
That's fine.
Um,
We've read it, so.
I'm glad everyone did their homework. So open top containers is what it's been, this condition number 14 is titled. And it's really referring to what we're trying to get at is that there is mitigation or eliminating any nuisances from the operation of the solid waste landfill. So we don't want any undue odors, litter, dust, debris. Those are all nuisances that can be addressed in land use. And so try to prevent and mitigate that. This condition was created as open top containers, and you didn't want anything blowing out of the container. What happened during this process of going through with the Planning Commission, they had some work sessions and they had their subsequent public hearing. We got into coming up with many different definitions for modes of transportation, different types of containers or gondolas. We started defining all modes of how waste can be brought in and taken away from the site, and the condition was growing and growing and growing from even when it was proposed in 2012. There was a similar staff report presented to the Planning Commission, and at the Planning Commission hearing, at that end of the staff report, there was a brand new condition proposed, and it was titled transport, that addressed the modes of transportation. And during the Planning Commission hearing, as this was being very debated and very discussed heavily amongst all the members of the Planning Commission, there was a moment in time that they just said, you know what? At the bottom of the staff report, there's a recommendation for a new condition called transport. Why don't we just focus on the transportation and the nuisances, and really we're going to put the onus on Waste Management and how they're going to address that. So if they're going to address it with using a binding agent or tarping, that is their responsibility. They need to report to the county how they're going to address that. but really the impetus here is to mitigate or eliminate any odors, dust, and debris. And so through that whole discussion at the Planning Commission, they are making a recommendation to insert the transportation new language under this condition. So it is
Much more concise.
it is very concise, and we're trying to focus on, again, what are we trying to get at? We're not trying to dictate every means of how you eliminate that stuff, because again, the binding agent is kind of new, and there's a particular one, if you want to call it brand name, of dirt glue out there. We can't forecast what other technologies might come out that will help them make waste management mitigate all of these nuisances. So we're trying to focus on what is the nuisance, who can report a nuisance, so if you're referring to the odors or the dust and debris, that's what our community can report on. And then if we do have a complaint, then we take it to Waste Management and say, hey, this is what's being reported on. How are you going to mitigate that? So that was the whole discussion regarding this condition, and that's where we got to the proposal now. And Waste Management was okay with this at the end of the Planning Commission hearing at this time. If there's a different opinion, they'll tell you today. But so the staff, Planning Commission, and Waste Management at the conclusion of the Planning Commission hearing agreed to change this and retitle it to transport, and that the transport condition would state, committee shall conduct its operation, including, without limitation, managing all deliveries to and from the site by any mode of transportation and from any point of origination in the manner required by applicable law, and so as not to create a nuisance or otherwise generate complaints, which may be verified by the planning department, of odors, litter, dust, debris, mud, leakage, and other negative impacts to the public or adjacent lands. So that's a lot of food for thought for the county court, but hopefully I summarized that. This condition wasn't handled lightly. There was a lot of discussion. There was a lot of discussion between staff and Waste Management. There's a lot of discussion at the Planning Commission level, and that's where their recommendation is coming from.
Council, did you confer with council on that in any way?
Yes, so the new proposed transportation condition was proposed by legal counsel, and so that was presented in the staff report to Planning Commission. Legal counsel was participated via Zoom during the Planning Commission hearing. I believe he's on today, and so he can state that if Garrett is all right with me commenting, he's okay with that. He's okay with what finally ended up being the recommendation.
Garrett just unmuted, so maybe we give you a moment if you want to speak to that.
Yes, absolutely. For the record, Garrett Krosek, Land Use Counsel for the county. Nice to virtually meet the county court. I can confirm that we worked together on that language regarding transport and nuisance together, and that I do find it acceptable.
Thank you.
Thanks, Garrett.
Are there any other questions regarding that condition?
I guess I just, because we've asked them in the past to tarp an empty container as well, just from the chance that there may still be debris in the, I'm talking trucks. I'm not going to go to not know cars at all here. This says managing all deliveries to and from the site. That doesn't really address whether you're requiring them to continue to tarp an empty container. Is it?
I would interpret to and from means whether it's full or
It says
empty.
deliveries.
Okay.
We're not delivering anything from the site. Those are empty containers. So that would be my concern with that. Not just that amount of words. Just words.
So if the county court is, the county court gets to deliberations, and if the county court is in favor of the proposed condition, the county court can wordsmith and propose additional language and clarification. So yes, the county court can, you can take this and during deliberations, you can direct staff to change that. You bet. That is all within, your authority to do that. And thank you, I do understand where you're coming from. Yeah, it can be, we're trying to make this so there's only one interpretation.
Right.
So
Yes.
if we can make things even clearer, that is one of our objectives of going through this process. Thank you, Commissioner. Is there anything else regarding that condition at this time? Okay. Condition number 15. Condition number 15 currently had a letter A and a letter B. Letter A was special waste, titled special waste, and B was titled technology and practices. So the first thing with condition number 15 was we're separating it into two different conditions. That's a recommendation that was accepted and promoted by Waste Management, County Planning Commission, and staff. And so, without reading all of this, because there was some discussion, condition 15 would be the special waste component. And what we ended up doing was, special waste is actually addressed in the host fee and road maintenance agreement. And since there's another agreement that's referring to special waste, the objective here, and hopefully we captured it, was to incorporate and use the same exact language that's already in the host fee agreement for special waste and incorporate it into the conditional use permit. So we have like language, and we're, again, trying to eliminate room for interpretation and different definitions. And so the proposed amendment for special waste is language that was taken out of the host fee agreement at this time. And that is a recommendation from Planning Commission, staff, and Waste Management concurs at this time to have an amended wording for that specific condition. Condition number 16 is titled Arlington Condon and County Waste Disposal. This is a very lengthy paragraph. And so the objective and the approach that was taken by staff was to try to pull out the important bullets and try to create bullets from this paragraph so that we really tried to get at what was the impetus and the importance of this condition. And so hopefully there wasn't anything lost in translation. And at this time, again, Waste Management, county staff, and Planning Commission are proposing recommending amended language to this condition. So the condition is incorporating bullets or letters A through D, pulling out specifics regarding this condition. And I'm just going to hit those, and so everyone understands what we're talking about. So the title would be Arlington Condon and In-County Waste Disposal and Recycling. The first one, number A, would be permittee must provide and maintain recycling transfer stations within or at a designated location by the applicable city, the city of Arlington, and city of Condon for use by residents at no cost. Number B would be permittee must provide a recycle area at the site for use by residents at no cost. C, permittee must manage, dispose of all residential waste generated in Gillum County and delivered to the site at no cost. D, the owner or operator of a commercial or industrial facility located in Gillum County may dispose of waste generated within Gillum County at the site at no cost, unless or until the amount of waste disposed of by the owner exceeds 200 tons per year. At such time, the owner or operator shall begin paying a rate negotiated with the permittee on all waste above the 200 tons delivered annually to the site for disposal. So the recommendation here is we're trying to provide some clarity and more concise language, and we're proposing to amend that condition. Condition number 17 is titled litter control. And I'm just going to bring in condition number 18 right now and just hit reference. Condition 17 and 18 in 2012 refer to litter or patrolling or picking up litter. So first out the gate is the proposed is to combine those two conditions into condition number 17. And so in an effort to make this more concise, and to try to not, the current condition of 17 was listing out a lot of measurables of how this was to be done. Waste Management has a litter control plan they have to submit that's been approved by DEQ, the Department of Environmental Quality, as part of their operational operational plan that is a requirement of the permit for the solid waste landfill down at Columbia Ridge through Department of Environmental Quality. Again, for sake of consistency and for trying not to miss something, again, kind of with transportation, we were getting so wordy, and so we were being very specific on how they needed to take care of the litter control, that the proposal is to clean it up and refer to an existing agreement that's already been approved by DEQ and will be copied to the Planning Commission and the County Court, and it's referred to now as Exhibit B of what that litter control plan. I reviewed the plan. The elements that are called out as bullets, you could say, currently under 2012 are included in that plan. And so the recommendation is to combine number 17 and 18 and now reference a new Exhibit B, which would be the litter control plan. And at this time, the Planning Commission staff and Waste Management are in favor of this amended proposal for 17 and 18.
So
And-
is their
yes.
litter control plan and operations plan, is that all tied into their permit?
Yes, it's a
It's all-
requirement of their solid
okay.
waste permit with the Department of Environmental Quality.
Okay, perfect.
And so I will just point out, in 2012, the patrolling or picking up litter was annually. Everyone agreed that that was not that was not sufficient. So now it has been reworded to at least weekly. The patrols will take place, and we've identified where the patrol areas will be at a minimum. Obviously, Waste Management would do due diligence if it's gone beyond that, and they'll take care of it. But all those measures are in the litter control plan. So 17 and 18 have been combined as a proposed amendment. So I'm not going to talk about 18 because I just rolled that into 17.
Yeah.
So we'll go to number 19. Number 19 is titled Visibility of the Landfill. One of the elements of this condition was that Waste Management was required to plant trees to create a buffer or visual buffer from Highway 19, visibility of the landfill. Everyone acknowledges that trees are not going to, they're not indigenous, they're not going to work, and by leaving trees in this condition, Waste Management is not going to be in compliance. It's just not feasible. And so we, staff worked with Waste Management, and we crafted language that is, it's technical is what's being proposed, but the basis of it, and if I summarize correctly, and again, if you need more clarification, we do have Mike here, Einstein, the engineer with Waste Management, who can provide more information on this. But in essence, if I can dumb it down as best as I can, Waste Management is going to create a berm. And so there's going to be like a ledge berm out there. So visibility from Highway 19 is going to be dirt, and it's going to be revegetated to natural grasses. And behind that is going to be the landfill. So as the landfill approaches its maximum height limit that's been approved, people should not see it from Highway 19.
Looks like a hill.
Yes,
Yeah.
yes. And so they're going to be using the resources and technology and equipment to berm it up, and it will create, again, that natural environment that people won't see, and it's more cost efficient and productive efficient for the landfill, because as they're excavating for cells, they can be moving the dirt and creating this berm. And it seems to work for everyone. Everyone agrees with the language. Again, the proposed amendment language is a little technical. So if you need some more information, we have an excellent resource available to us, and if the county court needs that during the Waste Management's presentation. But again, so the recommendation at this time from the Planning Commission staff and Waste Management is to provide an amended language for this condition. Condition number 20 is titled Landfill Gas Collection. I'm going to read some of the proposed findings on this. The condition was added after the county approval for the development of a gas to energy facility. The condition includes a component about the county, court, and Waste Management entering into a potential agreement at which time the gas to energy facility begins to sell electricity. Neither the planning commission nor the planning director are a party to the reference of a potential subsequent agreement. This would be best suited to be included in another agreement. However, similar to the host fee agreement, it may warrant keeping a condition of approval as reference. The planning commission discussed eliminating as a standalone condition. However, it is an item of reference under the new proposed technology and practices condition and on the new proposed Exhibit A, the facility site plan. The consensus of the planning commission was to recommend eliminating this condition as a standalone condition and list or reference under the new technology condition and on Exhibit A. Staff was asked to double check the host fee agreement to see if this was referenced in the document. During the planning commission hearing, Ms. Shannon with Waste Management, we didn't have the host fee agreement with us, but she recalled that she thought it was in there. And so I did further follow up, and staff does further note now the host fee agreement was reviewed, and this topic is actually referenced in the document of the host fee and roadway maintenance agreement under number 9. So with that further knowledge, it would be at this time the recommendation of planning commission, staff, and waste management would be to eliminate this as a standalone condition, reference it on the new proposed Exhibit A, and reference it under the new proposed condition for technology. Condition number 21 is titled Rail Yard Operations. And the findings here, a rail yard is integral to the operations of the site. It was noted in the original application that rail was a viable option. It is important to capture and track the development, upgrades, maintenance, and expansion of the rail yard. A map that illustrates the rail yard should be required. The Planning Commission did ask staff to clarify whom is the party that it has issued the reference permits. And so at the Planning Commission hearing, staff provided a proposed amended language. And in that proposed amended language, there was called out bullets or A, B, and C of existing permits through the county or other agency that refers to activity at the rail yard. And so the proposed amendment that has been called has been changed. I did quote that Waste Management has received a conditional use permit for the activities at the rail yard. And so at this time, the recommendation from the Planning Commission, staff, and Waste Management is to recommend to the county court the amended language, which is calling out some of the existing stuff that's out there. It's creating a baseline of what is at the facility as of 2020. So as you look at that proposed language, we're referring to that the rail yard today has 6 tracks out there. They have an associated gondola unloading facility, and with some coverings over 2 or more tracks. So again, some of the clarity and the conciseness that we hope to achieve in these amendments being proposed is also to create the baseline of what is being operated at the facility. Condition number 22 is titled Applicable Laws and Permits. This is one of those areas where the Planning Commission and staff differ at this time, but it's not a strong difference of opinion. Planning Commission, it doesn't hurt to keep this condition in here, although I will state that even if this condition stays, I'm not sure what we are calling out for compliance. How is Waste Management complying with this condition that isn't already spoken to? So we refer to the operations plan. We refer to them maintaining their permits with the Department of Environmental Quality. We're referring to other agencies already throughout the other conditions. So this is kind of a double effort by leaving this in here, because we're actually we're doubling up on an effort that's been already quoted under other conditions. So staff is of the opinion this condition is not necessary at this time. We're calling out those specifics under like transportation and some of the other conditions we're already referring to. Again, I believe the Planning Commission doesn't have a problem if it goes away. Their recommendation at this time was it doesn't hurt, so they're recommending to just keep it with no change to the language, keep it status quo. Staff is of the opinion, let's just make it go away. We have a lot of conditions, and if we can eliminate one that's not necessary at this time, let's go ahead and clean up So that would be where we differ a little bit in our recommendation to move forward. Condition number 23. Condition number 23 is titled Plasma Gasification Project. This will be probably easier if I just kind of summarize this. Back in 2016, thereabouts, Waste Management came to the county and said, hey, we have this new technology. We're coming to the county and we want to do something different with some waste. It was referred to as the S4. So if people were around and paying, saw some stuff in the news at that time, it was a new technology. They brought in private partnership to that technology. Fast forward to today, Waste Management is no longer a partner of that project. Waste Management does lease land to the current owners, which is titled Initech, to that operation. So at this time, the recommendation is to remove this as a standalone condition. However, we will, it's recommended to include it or identify it under the new technology condition and to identify it by location on Exhibit A. So hopefully I have summarized that. Again, right now, today in 2020, Waste Management has no ownership, no partnership in this activity for the plasma gasification project. The current company or owners are referred to as Initech, and they have received a subsequent conditional use permit from Gillum County for the activity. They are not operational yet. They are still going through the permitting requirements through the Department of Environmental Quality. So it's the recommendation again from staff, Waste Management, and the Planning Commission is not to have this as a standalone condition because we can't, Waste Management can't comply. They're no longer owners in it. Okay, so that we just ended with condition number 23. That is the end of the conditions for the current 2012 conditions. Now being proposed is a new, brand new condition for the county court to consider, and that is to be titled Technology and Practices. So I want to just recall back or refer back to condition number 15 and bring the county court back to 15 where there was an A and a B. A was special waste and B was technology. So this brand new condition pulls out that B and we're going to title it Technology and Practices. And so the proposal to the county court is to add the brand new condition, and that will be, you know, in numerical order at the end of however we flesh all this out with the county court during deliberations. And the recommendation is by the Planning Commission, it is by county staff, and it is by Waste Management to call out this new condition titled Technology and Practices. And what I want to refer to again, or just call out to the bring to the county court's attention, there's an A, there's a B, a C, D, and E, and what we're trying to reference there are existing associated accessory permits that have been issued to Waste Management that all connect to the activities out there or what's being allowed on the land out there of the solid waste landfill. So we call out the research and development permit. We're calling out that there's a trucking permit out there, which is currently held by Walsh Trucking. Again, now we're referencing Initech, which was that condition 23. And then Waste Management also has received a conditional use permit for composting area. They have not exercised that conditional use, but they have been issued one. So we're creating a baseline of activity and operational areas and what's again occurring out at the facility and sites. And again, all of these A through E are also labeled and identified on Exhibit A, which is brand new. We've never had an Exhibit A. So then now I'm going to focus on Exhibit A. So another brand new condition of approval is being proposed for consideration by the county court, and this is being titled Facility Site Plan or Master Plan. And again, this condition is actually Exhibit A. We're referring to a map, we're referring to activities and identifying any structures, cell development, roads, maintenance facility, the rail yard, all of this will be on one illustrated map. It's going to be referred to as Exhibit A. Waste Management will provide updates annually if there's changes to Exhibit A to the Planning Commission. And again, they'll have a combination of all that when the 5-year review comes up as to the county court. Here was Exhibit A in 2020. Here we are in 2025. These are the changes or additions. And so now we'll have a good baseline moving forward of all the activity. They'll also, under this new condition, is they'll provide Waste Management, the committee will provide a aerial photo of the site to the planning department on an annual basis. At this time, the recommendation is by the Planning Commission, staff, and Waste Management. We feel this is a very, very beneficial condition and addition, and we all support it at this time, and we hope that the county court will support the recommendation and include this under their final decision to incorporate this new condition. So that actually wraps up the staff report. Unless, are there conditions specific of staff at this time? Because I know the applicant would be next. So if you do have, if the county court has questions for the applicant, they'll come up. But is there anything, and this is not the last time the county court can ask questions of me, but is there anything for staff at this time? Okay.
Great. Thanks, Michelle. Let's go on then to the applicant. The applicant is now given an opportunity to address the county court. Let's shuffle some chairs maybe and
Said you want me here.
Took the
There?
seat on the end of Michelle, so Houdini picked you up just fine.
6 feet apart, ladies.
My name is Leah Shannon. I'm the EP manager for Columbia Ridge Landfill down in Arlington. And first of all, I would really like to thank Michelle for all of her help with this because it's been really a huge job and she's done a really good job with it. So we've worked very closely with this. We've gone through it a million times. I'm pretty sure it was 1 million. And I think we've got a good product here. I don't feel like it's necessary for me to go through these conditions individually. We've already heard Michelle's presentation. It's long, and Waste Management feels like the proposal today before the county court is good and that we're on board with it. We've heard a couple of comments. Those are words. We can fix those. I think that we can all be on the same page with this, and I feel very good about it. So I don't really have any other comments. Other than that, if you have questions, I'd be happy to try and answer.
Any questions, Sharon? Yeah, I know this is a heavy lift, so thank you for being so cooperative with planning and.
No, it was a good learning experience all the way around.
I will echo that, and I will thank Mike and Leah for their participation. We wouldn't have been able to give what I believe is a very good product without their cooperation and enthusiasm and just time and dedication. I mean, this did take a long time, and everyone knew we wanted to get there, and we just worked diligently to get there. So I was very appreciative of the work we all put in.
So if no one has any other comments,
No,
Waste Management is very on board with the product that we have.
Great. Fantastic. Okay, so then we'll move into the public testimony portion of the hearing. At this time, we'll receive public testimony. Proponents of the application shall speak first. Opponents of the application shall speak second. And neutral testimony shall proceed third, and any agency comments next. So Michelle's going to get this sign-in sheet. I'm just going to remind for folks who are on the phone or on Zoom, if you dialed in with your phone, you just need to hit *6 to unmute yourself. We'll give you some time to do that. And then if you signed in via Zoom, you can either unmute yourself if you know how to do that. Also be great if you could just shoot Lisa we may have to talk to the city about quieting it down. If you could shoot her just a message if you want to be in the queue, so we can get to everybody.
Would it be okay if we took a short break?
That would be great, actually. It's 11:20, so we will just take a quick break. We'll also talk to the city crew about quieting down, and we'll be right back.
Oh, they work somewhere else.
And then if you're dialed in through the actual Zoom, if you're on your computer, you can unmute yourself, and as soon as we get started, we'll go right into proponents first.
I have two things I just want to bring up, because this is spelled incorrectly, and this should say recycling.
I think somebody else did, right?
I got it.
Yeah. So it is an edit.
Okay.
It's the clean version. But thank you. You look at something 10 million times and you're like,
Well, yeah.
Especially a word like preemption. It's like, how many E's are supposed to be in there?
Well,
You know?
it was spelled right down here, and I thought, it's right, it's funny. It's funny with two E's.
it does look funny.
All right. Are we ready? Okay, we will come back in from our little break. And at this time, we'll receive public testimony. Proponents of the application shall speak first, then opponents of the application shall speak second. Neutral testimony shall proceed third, and any agency comments next. So is there anybody who wishes to speak in favor of the application? Start with folks in the room. I don't have anybody signed up. Did anybody not sign up that wanted to? I don't see anybody. How about online or via phone? Did anybody want to speak in favor? If you're on your phone line, you just need to hit *6 to unmute yourself. So give folks just a second to see.
I'm not seeing any requests come through chat.
I do not see anybody, so we can move on to, is there anyone who wishes to provide neutral testimony? And I don't have anybody who's signed up in person for neutral testimony. Anybody online? Again, just hit *6 to unmute your phone if you'd wish to provide neutral testimony, or unmute yourself on the Zoom platform. Just pause here for a minute and let folks have a second to do that. And I do not see anybody. So then we will move into, is there anyone who wishes to speak in opposition of the application? We do have Sina and Jim, right, who are interested in doing, in testifying. So if you guys want to come up,
Sure.
that would be great. You know what?
We almost need a table.
You want me to pull another thing?
Oh, you said still.
I can move if you guys want to both sit here. That way we.
Set this one.
Yeah, let's use this table, and then we'll just put you guys at the end. That way we've got our good distance. That works great.
Thank you.
And we're rearranging some furniture here, so for folks who are on the phone or on Zoom, if you want to be in the queue, again, you just hit *6 to unmute your phone, or send us a little message if you're on Zoom so that Lisa can keep track of folks who want to be in the queue. And then if you guys could just state your names and addresses for the record, please.
I'm Alcina Wright, and I'm at P.O. Box 357, Arlington, Oregon.
James Wright, 1145 Philby Drive, Arlington.
Yeah, just to be different. Huh?
Not the same.
Yeah. Yeah, I live in the post office box.
I have a handout that I believe to be relevant, but I don't know how you do that with a pandemic. So I would like to have our commissioner see. I can just read it.
I could probably hand it out.
Yeah, why don't you give it to Teresa? And that way it can be part of the record as well. Great, go ahead whenever you're ready.
Okay, I'm gonna go first.
Okay,
And as I think most of you know, I was the planning director in Gillum County when the landfill went in and sat in on all the original negotiations and stuff that went on at that time, and was very much involved in the relationship we built with the company and with Metro to make sure that everybody's interests were always protected. And I feel like that right now, that is very lacking, that has kind of all shifted away. And that's the reason for a lot of these conditions that we're changing now, was that there was a real fear that that could happen. And if we didn't mention them here, maybe 10 years from now, nobody will know there's a road agreement. That if it's not mentioned here and maintained in the conditions of approval, that those things can go away, or they can just become part of the history, and they're not, they need to stay relevant. And I think it's extremely important to have that relationship, especially with Metro. We could always go to Metro if there was an issue that wasn't being addressed, and they would stand with us to make sure to hold waste management to file. And I have a real fear that we're becoming a community that does everything to make it easy for waste management. And I know they're a Fortune 500 company and all of that, but it's very, very important, I think, that we maintain our relationship with them, but that we always remember our job is to protect the citizens of Gillum County. It doesn't matter what waste management wants. It matters what's in the best interest of the people that live here. And I think they used to do a lot of things in the community, and that is all kind of faded away into the sunset. And there's some things I think we need to be cognizant of that we need to protect. And through having that relationship with Metro and waste management, the county court used to go and visit the president, who is Mr. Fish now, and I don't know that this county court has ever met with the head of waste management to let them know that we do have concerns in the community. And, employees change and policies change, and I just feel like that continuity is getting fragmented. And I would like to encourage you in this process to just be slow down, take your time, and be very cognizant. And I think I will turn it over to Jim, who's going to kind of fill you in on some of the things that have gone away.
okay. Great.
Thank you. I would like to commend Michelle. It's obvious whether I agree or disagree, or whether the commissioners agree or disagree. You've done a lot of work, and I have great appreciation for the time spent and the work that you've done. I have an article here that was published by the Times Journal on June 18th, 1995, says Gillum County Commissioners hear of a recent merger of Oregon Waste Systems and Chemical Waste Management. There will be no reduction of workforce at either facility, and the merger will allow the two companies to work jointly. My reasoning for this is much of the time when there's an issue over at Chem Security, by bringing in things that were illegal or substances that are dangerous or could be dangerous, Waste Management could always say and has said, oh, that wasn't us. It is us. This is the article that proves that they're all one. And I would like to go back in some history, and I was in the beginning of the negotiations too. I was on the other side of the fence when Gillum County Commissioners beat us down and said there'll be closed top containers only, right? We even had to change the configuration of the loading method. We could no longer top load. So I do believe there was something there in addition to conditions called expectations. The expectations of the people that pay taxes and live here. So I'll try to rush this along. First 10 years, Waste Management, as the largest employer, supported, donated, participated in many local activities. Firefighting. Lord, they had all of the equipment, trained the personnel. We went off with North, South, Gillum County. We could beat any fire down in a short time. That goes away. Sent employees for EMT training and encouraged them to go to EMT training. Built and supported local daycare. Built infrastructures as needed in the city of Arlington. We had holes in the streets in 1990 in Arlington that would swallow up a Volkswagen. Waste Management, combined with some other volunteers, went in, paved all of those, and replaced them. They also, on several streets, brought in the equipment that the city doesn't have to rebuild the infrastructure, sewer, and water. They furnished the garbage truck in the city of Arlington because it only operated when it chose to. Participated with Gillum County volunteers in the construction of a football field to include the lighting of that football field. Major sponsors of the county fair, Arlington Rodeo, and far too many more to mention. They were a good custodian of the opportunity given to them by our commissioners and the taxpayers. I thought they did a great job. I was always proud to be associated with them and work on those projects. Somewhere around the year 2000, these things beginning to slide. And I do believe it's change in commissioners, change in management of waste, and kind of that relationship that we had with Metro Waste and our commission. And that went away, and the conversations went away. And well, we met maybe once a year or something and kind of hit the highlights, and everybody felt good, and we had a cocktail and went home. It went downhill. We now have open top containers coming through the city of Arlington. That has to be some kind of a violation. And I know they're trying to address it, but cover them. The agreement was that everything would be closed, and Waste Management's in violation here because they just decided to change that and start bringing open containers through town. They no longer engage in any of the fire suppression. Nothing. They don't furnish equipment, personnel, nothing. And many times, North and South Gillum County fire departments are defending their properties. So we have no understanding why all that went away. Working outside the CUP, they have a designated area where they're to work. I have a map here from the assessor's office that shows 3 areas where they're working outside of that area. One of them is the extension of the railroad, is outside of their permitted area. They've accepted materials out there that no one in Gillum County agreed to. How that could happen, we have no idea, but we're stuck with it. We have to live with these things. This is all relevant information because they have violated, they now need to come to the table and renegotiate many terms with this commission. I have safety issues that I'm very concerned about. We're now producing something called hydrogen sulfide. Very deadly, very poisonous. Have they talked to the commissioners about that? What are the mitigations? What are they doing about it? So Gillum County, on the other hand, has been very supportive when Waste Management needed a hand with the Metro contract, and Metro wanted to know that Gillum County is very involved. We went out and crushed hundreds of thousands of dollars of rock at taxpayer expense to show Metro that, boy, we're a good partner. What did we get? I don't even know if we got a thank you letter for that. The citizens of Gillum County have a right to expect the same participation that we had in the beginning, even if it was over a handshake. It doesn't matter. The proof in that pudding is they did it. For many years, they took care of us, and they were responsible as the largest employer in this county to what the expectations were. Today, you are reviewing and considering the elimination of several original conditions of approval. And those conditions are there for Gillum County residents and their protection, not for Waste Management. If Waste Management could, they'd do away with all of them. We know that. So how is it that any amendments or changes to those original conditions benefit Gillum County residents? Not sure. I think it's only to make it smoother and easier for Waste Management. So here we are again spending all this time and energy for Waste Management. I would encourage you to slow this process down, get waste back to the table at corporate level and maybe even Metro if necessary, to get back to those days when we can sit down and talk about all of these different things that waste used to do that they have stopped doing. And get to a point where we have oversight out there. Maybe we wouldn't have some of these issues with regard to the types of material brought in if we had an oversight individual out there that was a full-time employee of Gillum County and was the cost of which was reimbursed by Waste Management. And that person would report to you people. I thank you very much for your time. It was my pleasure.
Is there anyone else online? I don't see anybody else in the room, but how about online or on the phone who wishes to speak in opposition to the application? And if you dialed in with your phone, you just need to push *6 to unmute yourself. And then if you're on Zoom, you can unmute yourself or send us a message if you're having trouble unmuting yourself, and we can do that as well for you. So is there anybody either on the phone or online that wishes to speak in opposition? Give me just one more second. I do not see anybody. Is there anyone representing an agency that wishes to speak? And have any in the room here? How about online? I do not see any. So we will move into staff comments. Does staff have anything to add in response to the testimony?
I don't have anything to add. I will say when the county court gets to deliberations, there may be some even a few wordsmithings or tweaking that we need to do. I noticed in the draft that was published a week ago, there were some typos. So I don't know if we need to call those all out during deliberations, but some of those typos will need to be fixed for the final product.
Okay. Questions or clarification? Sherry, do you have any questions of staff?
I do not.
I don't either. You guys can sit down if you want. Thank you for participating. move into the applicant rebuttal. Leah, did you have anything you wanted to say in response to the testimony?
I would just like to say that I appreciate Mr. Wright and Mrs. Wright's comments, and I will definitely take those concerns back with me. They're valid, and they probably do need to be addressed, so we'll definitely take those into consideration.
Okay. All right. So, let's see. It's the county court's discretion to continue the hearing or leave the record open. We can, if additional oral testimony is necessary, we can continue the hearing to a date and time certain. If an additional written testimony is necessary, we can leave the record open for a minimum of 7 days and set a date and time certain for deliberations. Or we can close the hearing now and proceed to deliberations. What do you prefer, Sherry?
Well, I have some changes that I'd like to see put in, so I guess I'm ready to deliberate.
Okay. I agree. So if you don't have any further questions and nobody else to rebut or do anything else, then I will now close the public hearing. And I think what we're anticipating today is that we will, Sherry, you and I can deliberate, and then if there's changes and we think that we'd like to vote on it today, then I think the intention is Michelle will make those changes and then bring us back a clean copy later in the meeting. So we'll go back into our regular session after we deliberate and then take this up as our last agenda item to give her time to address any edits if we decide we'd like to take it up during today's board meeting. So with that, I think we're in deliberations.
So, number one, review timeline, I'd like that to read, on or before December 31st, 2025, and every 5 years thereafter, the conditional use permit must be reviewed at a public hearing before the planning commission. I want to strike, the planning commission may reapprove the conditional use permit after considering the following, and add, the review shall be fulfilled if the county court determines after public hearing that. And then the rest of the.
So you'd like to continue with the 1-2 kind of review with the planning commission
Yes,
doing
I
the
believe
hearing.
this is a county court conditional use permit, not a planning commission conditional.
Yeah, I would support that as well. I think you guys have done the one thing we haven't said yet, but I just want to commend as well the planning commission. These are all volunteers and they spent a lot of time in meetings, sort of trying to consolidate these. So I appreciate, I can see that the chair of the committee is listening as well. And so I appreciate that time because I do think this is an improvement. I like that these are streamlined, a little less technical, and hopefully have some flexibility so that the county can address when things come up. Sometimes you think you want to address it very specifically in this, and then if it's not laid out specifically, you don't have the tools you need to be able to address a problem that you didn't anticipate. So that's my hope, that this will kind of get us closer to that goal. So I would support that change as well. So are you thinking, Sherry, on the verbiage, that it would be, let me just find what it used to say.
It used to say that it was simplified, which was good because the wording in the 2012 version had a little bit extra wording, but they struck the review shall be fulfilled if the county court determines after for public hearing, and put in that the planning commission may reapprove the conditional use permit, leaving the county court's determination out of that. And I
Okay.
want
To put it
to
back.
put it back.
So we would strike, so Michelle gets this, we would strike with the first reference to planning commission, would that say county court? So it'd say honor before.
The first sentence, county court. That's your.
Yeah, so is that what you're thinking? Should it have both references? Because what I was thinking was we could do, so it would read on or before December 31st, 2025, and every 5 years thereafter, the conditional use permit must be reviewed at a public hearing before the county court. And then what I liked on this language previously is the review shall be fulfilled if the county court determines after a recommendation by the planning commission, so that it's clear we need a recommendation. After a public hearing that, and then go into these.
Sounds good.
Did you get that, Michelle?
I sure hope so.
Okay. And so related to that, then, for me, on number 3, the preemption clause, that reference to planning commission should be county court. So it would read, and that's where one of the typos is as well, is in the preemption should have an extra E in it. So if it says, if a legislative body preempts or severely limits the county's authority to enact or enforce any condition of approval, the county court instead of the planning commission, since we will be
The approval body.
any other.
Number 5 was, I know that was something that the planning commission debated quite heavily, and that Michelle spoke with our council. It's the committee must obtain and keep current all, oh no, that's not right. That wasn't it. Hang on here. Well, our numbers changed so much, I got, I think I got out of whack. Let's see if I can find what I want to tell you.
Okay. I mean, while you're looking,
Okay.
I've got another one. So on 7, the draft order that Michelle gave us, number 7, that's the reference to the Seattle and Metro contracts. And I think the planning commission had recommended potentially eliminating that. I feel comfortable with that recommendation simply because we're locked into contracts already. And so I'm not worried about, Metro's got a 10-year contract. We'll have 2 conditional use permits come up. I mean, the reviews will come up twice before potentially Metro would walk away. So I'm not sure that that's a necessary provision to have, and could be just addressed in 5 years when the host fee gets reopened, is kind of what I'm leaning toward. I don't know how you feel about it, but it could also be left as a placeholder for a future court to think about when it gets reopened. So, I mean, I could go either way, but it's
I
part
think
of
it was
our
just
rules.
in there just to make sure that the county was a part of that whole process, and I'd like to see it remain.
Okay. Yeah, I can go either way. I'm not.
I'd like to see it remain, just because it's in there to say, we know these contracts are coming up, we want to be party to what those negotiation processes are.
Okay.
What I was looking at, number 5, was disqualification. All areas dedicated to landfill operation must be disqualified from farm deferral. Prior to expanding any operational area, the committee must submit a request to the county assessor to disqualify the additional acreage. And I'd like to see that left in as well. Just one more thing that says, we expect you to follow those processes and not make those judgments on your own without.
So we would be, are you happy with the planning commission's recommended language?
Yes.
Is that what you're thinking?
I think it simplifies things, but it also says, what we wanted to say, which is you can't disqualify anything, or you can't use property that's in farm use without making those steps.
Yeah, I'm comfortable with that. And assuming that since the planning commission recommended it, that they'll be.
That'd be
comfortable with that too. Other things that you wanted to talk about?
Well, I think number 8, we talked about Columbia Ridge Landfill and Recycling Center underpay. We know that needs to be corrected. And then number 9, committee shall conduct its operation including without limitation managing all deliveries to and from the site by transportation. And personally, I know that we're not going to tarp the gondolas. I get that. They've never been tarped. But I still would like to see something specific about over-the-road containers being required to have a tarp coming and going, whatever that language looks like. Just because it's specific. This can be, to me, this is broad and can be determined in any way. And I also know that transporters, those truck drivers are gonna take every way they can get to not have to roll a tarp. Especially if they're leaving empty and they think that they're completely empty. They aren't always. There was a reason for that initially, and that was to protect.
So if I'm hearing you correctly, if I'm going to just reach out and try to paraphrase.
Okay,
I mean, and I could bring something back to the court and the court can still tweak it.
okay,
But just so I kind of have maybe what I'm hearing from Commissioner is you would like a sentence in there that says any loads over the physical road system must be covered to and from the site. So whether it's full or empty, it must be covered.
Yes.
It's using the road transportation system.
yes.
Okay. So I just need to know if it's a full county court for me to come back with a sentence in that.
I'm comfortable with that.
Okay.
I do like that the language in what would be the new condition 9, 10, depending on where you put the assessor one in, that it's broad enough to address whatever comes next, because we don't know what transport's going to look like in 5, what new technologies come along. So I do like that the planning commission and legal counsel's given us some language that's provides some flexibility so that if the public's coming to us and saying, this isn't working, this is one of those areas where sometimes if you're too specific, you tie your own hands inadvertently.
Yeah, and what it did say was, it was specific, number 14, open top containers, which I agree does not need to be that specific as a topic. But it does say, I'm not sure we need to say, containers are utilized for waste or the containers must be fitted with tarps or otherwise tightly covered. So, like you say, tarps might not be necessarily the go-to covering in the future, but we just want to make sure that, I want to make sure that we don't have.
Yeah, so if we could maybe work on a sentence with council to try to address that,
Yeah.
that concern. I think the rest of the language is good
Okay.
in here, so I think we just need one more sentence to add and really clarify on that one point.
And clarify it is because there aren't deliveries from the side.
Any other, okay, so we're about at 9/10. Let's see what else we had in here. I thought, I liked the solution on the visibility of the landfill. I think that's gonna blend much more, so I appreciate that Waste Management was proactive in thinking about what would work, because that's obviously going to be a concern here in It'll be quicker than what we think, actually. It'll be here before we know it. I also really appreciated the technology and practices and listing where those other conditional use permits are. I think that will be very helpful for future courts and the public to be able to reference, okay, what's been approved and where it, it's just, when you've been a partner for 30 some years, things change. And so I appreciate that you guys added this, as well as the site plan.
Yeah, the mappings.
I think will be very, future courts will thank you for including this in I think. So were there other conditions or anything that the planning commission had recommended striking that you wanted to keep?
I don't think so. I think a lot of the others were not necessarily things that they eliminated, but that they combined to make it more, it's easier read and not as bulky, streamlined.
So if I could just ask the court, and maybe, does the court have the planning commission recommendation document in front of you?
I could.
I'm sure it's in here. Let me see which one.
Because we have copies in the back, I could look at it.
The planning commission ones, I think.
Oh, I do have, yeah, somewhere. I've got
That has the red with all the lines through it.
That one, yeah.
Yeah.
Did I keep that one? I'm pretty sure I did, because that's the one you and I marked up, wasn't it?
Yep.
It's in this
Yes.
file.
Lots of paper.
There it is.
Okay. Just so that I make sure I'm really clear in the direction, if we could just walk through all these one-throughs, and you can just say, 1, we're keeping that concept, 2, we're keeping, or 3, we're getting rid of, just so I have it on the record,
Yeah.
and there's no question. I would prefer that we just double up and make sure everyone understands what we're doing, if that's okay.
That's
Okay.
fine.
Okay.
So one, we talked about doing the
Right.
modification for the county court and still having the review by the planning commission, that 2-step process. And we didn't have any other changes to that.
did not.
So current condition number 2, the host fee and roadway maintenance, I don't have any changes to. The preemption was just the typo, and then striking planning commission and putting county court. The buffer, I didn't have any concerns about. Disqualification, we wanted to keep.
Yes.
The local vendors and services, the planning commission recommended striking. I'm okay with that. I think that's difficult to track what you mean by that if you're looking at compliance.
It had a purpose in the beginning, but at this point in time, it's lost its value.
The landfill operation makes sense to me, the applicable DEQ permits. Then obviously the road agreement got added to
Combined with
2. And then I'm okay with striking number 9 because it shows up elsewhere. And then I think we just need to note, because it won't be part of this, but just for the record, that I think we need to look at that advisory
Yes.
committee and how they're operating.
which they have not been operating.
Correct. And sort of have them
Yeah.
get engaged, but that's on us. That's our
Yeah,
thing
that
to
is our
sort out.
committee, yeah.
The transfer of ownership or assignment, I thought was a nice, clean way of handling that. I don't have any concerns. That's number 10.
So the only thing I would point out, if we're making number 1 reference county court, would you like to change the reference to county court in number 10? So it might take a moment to read
This
that.
one's number 10.
It's the transfer of ownership or assignment. So right now, the conditional, it
What is
says
it now?
the conditional use permit, I mean, it's a lengthy one. I like the language. I think the question is just who gets the consent. So the conditional use permit does not run with the land, may not otherwise be assigned or transferred without the prior written consent of the county planning department. The question is, you feel comfortable having Michelle make that call, or if we would like that to come before the court for transferring ownership.
I think it needs to come before the court.
That works for me. So let's make that Gillum County, or Gillum County Court. And then we decided to go ahead and keep the Seattle and Metro contracts as a placeholder. So that would be something we would add back in.
Okay.
12, the communications piece. I don't think we had,
Just the Columbia Ridge Landfill Recycling Center and A.
13, the out-of-state waste. I don't think it's necessary because we have the preemptive language. So I was comfortable with that. The open top containers is amended, and then we talked about doing the sentence referencing the on over the road transport. Was there anything else in that? Just that one sentence?
Yeah, just to clarify that deliveries are not going from, and we want to be sure that transport to and from, no matter if they're loaded or empty, and covered in some way.
Okay. Special waste, I didn't have any concerns about.
The only thing on special waste I did catch, at the very last sentence that starts with any, because of any solid. The question is, should it probably need to remove solid because we're referring to special waste, but do we insert special or do we just leave any waste? Because there's several definitions of waste under that ORS. So I would almost be inclined to just leave any waste
Yeah, I think that's great.
to clean that up a little bit.
Good catch. 16 is the in-county waste disposal and recycling. That looks a lot cleaner to me. I think that'll be easier for
I thought
folks to.
the lettering there and breaking that down is so much easier to read in the paragraph. Made it much more specific.
17 and 18 litter control, it made sense, I thought, to combine it. I remember when we did the review in December, I was like, why do we have two separate litter conditions? That didn't make a lot of sense. I like that we bumped it up to weekly. That's more, I think, probably in line with what the public would want to see and what's already happening out there. So I was comfortable with that. The visibility of the landfill, I already touched on. You are okay with that as well? The landfill gas collection, I feel comfortable striking that if it's in the host fee agreement already. So, 21, the railroad operations, I was okay with that. No changes. The applicable laws and permits. And that is going to show up.
The court order would have been number 16
Number 16.
in the draft.
Because it,
1 moment.
So this one, the planning commission said keep, and staff is like, we're doubling up on efforts and it's not necessary.
Got it. Yeah.
So to the court.
So we would be looking at striking that. Correct?
so actually that's number 5, the permitting must obtain and keep current all applicable permits and approvals. Is that?
I think that's Michelle's position, right? Is that it's already covered under that condition. So I'm okay with striking it.
Okay, so we're striking. Okay.
You're okay with striking it?
Yes. Okay.
Okay. 23, the plasma gasification project. I'm okay with striking that, especially it's covered under a different conditional use permit, so. And then 24, again, I thought this was a lot cleaner. I appreciated the references to the other conditional uses. So folks have a good guide to where else they need to dig into files to look for things.
And what other conditional use permits we need to be looking at.
Exactly. And then 25, I thought made a lot of sense. I think, I think that's a great
The
addition.
mapping is very, very helpful.
Thank you very much.
So did we catch them?
Yes,
You got
yes.
them all.
Yes, so I can make those edits.
Okay, so what we'll be doing, if you guys see the agenda, is so my intention, I think, if you're on board, is that Michelle can make those edits while we're conducting the rest of the meeting, and then at the end of the meeting, we can discuss whether to approve it.
Okay.
Does that work for
Yes,
you?
that's fine.
Okay, so stay tuned, folks. We will have it coming back to us at the end of the meeting.
I will go make those changes right now.
Okay, perfect.
I will excuse myself. Thank you very much.
Thank you. Leslie, are you there? She's there. So the question is, Sherry, do you want to just power through this agenda? What are you thinking?
No, that's fine.
Okay, Leslie, are you okay with just powering through the agenda?
Yes.
Okay, so we will go right into old business. 6.1, consider award of fiscal year 2020-2021 special projects grant to Arlington Education Foundation. So this, just as a reminder, we had met on July 1st to review the special projects applications, and we had made all the funding decisions on every application but one, which was the Arlington Education Foundation's application. Decided to bring it back to this meeting. So I'm curious what you guys are thinking. You've had some time
I
to.
did meet, I sat down with Brad Anderson and we talked about their goals and ideas and which their application was very thorough. And I think Commissioner Weatherall and I at the last meeting, what our issue was, is this is more of an operational grant as opposed to a special project. Same process that they're asking money for that they've asked for the previous 4 years. Initially, when they started, it looked like special grant. I don't think there was a designation at the time that they were awarded their first grant. But since then, I know we discussed it last year, and at that time, I think we let it fall through the cracks of saying, let's move this to an operational grant as opposed to. And after my discussion with Mr. Anderson, I feel they're also on track of our stipulation with an operational grant that they become sustainable. That is their goal. They are working very diligently with these grant writers and website people trying to establish, where they go in the future. I'd like, my recommendation after that conversation is either, I don't know what you feel is the best thing to do. Do we ask them to go back and submit an operational grant, or do we go ahead and maybe award them $10,000 and ask them in the next grant processes that they may consider, if this is the same thing they're going to ask for money for again, that they make it operational as opposed to a special project.
I could get on board. Well, here's what I'm thinking. I think I'm thinking along the similar lines, is that to me, we funded the creation of a website, I think, as a sort of one-off project. So I could definitely see us, I think in their budget, 5,000 of this would go to website development. So to me, we've done it previously. I think you could say this is a one-time project, and once they're done with creating their website, it'll be done. And then I'm wondering if you could say the same as well for their newsletter design, because in theory, once they have the template, they would just need to go back in and update that. And so I think those together are about $10,000. So I could get on board and just say, the things that we're funding here specifically are the website and the newsletter design. I also think with this, with the grant writers, my hope would be that they would consider just structuring their agreements so that when they're successful, part of that grant actually usually pays for their grant writer instead of having the county pay for the grant writer. What do you think about that approach, Leslie?
I think that sounds like a good idea.
Okay,
I like that.
okay. So we would be talking about funding them for the portion of the website design and the newsletter design specifically. So the total would be 10,000. Do we
So
have a-
10,000?
That's what I'm thinking, if that works for you.
Yeah, that's kind of what, along the lines I was thinking too.
Okay, I move to award a fiscal year 2020-2021 North Gillum Special Projects Grant to the Arlington Education Fund in the $1,000, and to authorize the county judge to prepare and execute a grant agreement reflecting the terms and conditions discussed.
Second.
It's been moved and seconded that we award a fiscal year 2020-2021 North Gillum Special Projects Grant to the Arlington Education Foundation in the amount of $10,000 and to authorize the county judge to prepare and execute a grant agreement reflecting the terms and conditions discussed. Is there further discussion? All those in favor?
Aye.
Aye.
Any opposed? The motion carries. Okay, we will get that out. And I think the other thing I'll just do for next year is as we're doing the operational grants, I may just flag it for Kelly that we might want to reach out to them
Yeah. See
before
where they're at.
and make sure that we're clear on where those things should go.
Because they're talking about postage and, you know, just those everyday things too that are costing them money that they want, you know, donations to go to the scholarships themselves. So they might have a smaller operation.
And one of the challenges too with, and I don't think we should change our timeline for this, but one of the challenges is because special projects comes after the deadlines of the others, that if folks miss it or don't understand which pot it goes under, then by the time they're applying for special projects, the other grants are already done. So we'll just do a little bit more outreach next spring to make sure that we're reaching folks.
All right.
All right, let's go on to new business 7.1, which is discuss full-time equivalent adjustment to Gillum County librarian position. And we have David Reiner. David, do you want to come up? And Mary here. So the request, just to summarize, is that the board of directors for the library is requesting that we consider moving the library director position from 29 and a half hours per week to full-time 37 and a half hours. Because we are, as a reminder, so everybody knows, the reason the request is for 37 and a half and not 40, which is I think the original request from the library board, is that the collective bargaining agreement does not allow us to do that. So it's limited to 37 and a half unless you're on road, weed, or maintenance. So.
And she doesn't need any of those.
And she's none of those. So I will turn it over to you guys to kind of talk about, maybe if you guys could help us kind of talk us through kind of the impetus, what you're seeing, where the need is, I think would be helpful. So.
You want to start, Mary? Okay. I just, from what Mary has shown us, I'll take this off. That's okay.
That's fine.
The duties that she's been conducting, and then the more, I guess with the COVID, the more responsibility assigned with that. And I just think, and I think the board's of the same opinion, that Mary's duties warrant having her to be as full-time. And I think she's probably been working full-time before this, prior. But I just think, and like I said, the board is also in agreement that those hours that she's doing warrant a full-time employee position.
Do you have more to add to that, Mary?
No, he pretty much.
So one of the questions I'm sure we would get from the public is, will this mean that the library hours are open, are changing, or will they be, are you anticipating that they would be?
They would stay the same, except for maybe on Fridays, open earlier, open like from 10 to 5.
Okay.
And then what we would really like to do in the summertime is open like from 8 to 5. So, because I would have summertime help for that.
Okay. One thing that I looked at that I just want to make sure that we're clear on is it doesn't look like you guys have accounted for meals on your hours.
No, we do not take a lunch break.
I don't think that's legal.
You're gonna have to take a lunch break.
So I was told by a previous board member, since we're limited on staff and everything, we don't have to, because usually we're by ourselves.
We'll have to sort something out because I'm pretty sure Bully would say we need to, but more, and just as importantly, your collective bargaining agreement requires you to take one.
So that's our busiest time of the day.
I know. So it may just be something, I mean, I don't think that this should hold up the actual decision, but I'm thinking in terms of looking at the hours, we just want to maybe have Lisa work with the board to make sure that we're in compliance with labor laws and with the CBA.
All right.
Make sure that the union is comfortable with whatever we come up with.
Okay.
Well, I think there's some leeway in, you don't have to go at noon.
Right.
You could go at 11.
Right.
And take a 30-minute break.
Our busy time is from the time we open to like 3 or 4 o'clock.
We'll have to get used to it.
It's within a given
It's a
number
lot.
of hours worked, so we have some flexibility
Okay, 'cause
around
we
that.
have
Same
one-
with your breaks.
Normal years, that's the school kids come down during that time too. We have a
Right.
couple classes and stuff, so.
And or when you say legal, would she have to lock the doors? I mean, would the library have to be shut down?
We would probably need to do that unless you've got, you know, if there's a day when you've got overlap and you've got like a student and she could probably do that. But the CBA is really clear that if, so say somebody interrupts her, say she brings her lunch in, but
Right.
somebody interrupts her,
Right.
that doesn't count as her lunch break then. As soon as she's required to perform duties on behalf of the
Right.
county, that
Yeah.
means that she didn't get her lunch break,
Right,
basically.
Okay.
So, I mean, again, I don't think that it's necessarily a holdup to getting this done. It's just something we need to make sure that we're
Okay.
doing.
Yeah.
Leslie,
Gotta follow law.
do you have thoughts or comments or questions?
I have to unmute. Just something that I thought of after David started talking about it was, you know, COVID, you know, the increased activities due to it. After that's over, if we ever get to go back to any kind of normal life, do we still see that these hours are necessary?
Yes, because we will still be doing all of the cleaning. We have to clean every book that comes in, and we have a bunch more cleaning than we do every day now. Just, which is a good thing.
Yeah.
Yeah. I mean, the whole library gets cleaned pretty much every day. Well, that's bathrooms cleaned every day, books cleaned every day.
So could it be though, because I think Commissioner Weatherall's asking, you know, once we have a vaccine, come on scientists, how does that look then? And so would it,
Busier than we'll be back up to where we were before.
Because you'll have more.
People in.
Yeah.
And kids, we're not having any kids in right now because they're staying home. We don't have the after-school kids or the after-swimming kids and stuff like that.
So I guess my question would be, this is something that's been needed for a long time and is not just in response to our current situation.
Correct. So the library was formed in 1927, and the board from that time has been trying to get a full-time employee at the library. So
we're on track.
We are on
track
track.
for a decision.
Much progress.
It just took a while.
Yes.
So if this is something that the court would entertain, it's a because obviously we need to look at the job description and make an adjustment there. So I don't think I actually need a motion today, but just a direction from you guys on if this is the direction you'd want to go in, then we bring the job description back. We also, I think I need Kelly to check on this, but I think we would need to do a supplemental for the budget because we didn't budget for a full-time position. So she'll need to run the numbers and see whether we're within the 10% or whatever we can be to go over, or whether we would need to bring that back. But I'm really just looking for direction from the two of you on, is this the direction you want to go? Are you ready to make that decision now? Is it something you, and
I'm gonna wait to see Commissioner Weatherall is gonna speak. Are you speaking, Commissioner?
what do you think, Leslie? You can go first.
The people, Liz, I can hear you. Judge Farrar, I can hear you pretty well. Commissioner Wilkins, you're a little tough to hear sometime. And also the people that come to the table to talk to us, if everybody could talk pretty clearly and
Louder.
voice, it would be great.
You know I can talk loud.
Perfect. Thank you. I think we're ready to, I feel ready to move forward. If
Okay.
does.
Yes, I think we should take the recommendation of the board
Okay.
and make it happen.
Okay.
Thank you. We appreciate that.
Leslie, you are in agreement?
Yes.
You're nodding? Okay. So what I will do then is we don't need a motion today again because it'll be on the actual job description that we need to do that. And then I will check in with Kelly and see if we need to do a supplemental for the budget. It doesn't, we can do this and clean up the budget after the fact. So we will put this on, and I'll just ask Lisa to work with the board and with Mary to get the job description so it's ready to come back before the court. If that works for everybody.
Sounds good. What do you think, Commissioner Weatherall?
Yes. Thank you.
Sherry's yelling over here.
Well, thank you very much.
Thank you.
Yeah.
Thank you for coming.
And we'll be in touch as soon as we get the description started.
Okay, thank you.
All right. Let's go on to 7.2, which is consider approval of resolution number R 2020-22, a resolution adopting a safeguarding personal identity information policy. So if you recall, during our June 16th meeting, we adopted the cybersecurity policy. We were up in Arlington, which was required of us to buy the cyber insurance coverage, the extra that we approved. So we turned all of our stuff in and we were feeling good about ourselves, and CIS came back and said, well, do you have a safeguarding personal identity information policy? And we said, no, you didn't mention that previously. So they require that we have that for the coverage as well. And they have provided a draft, which is in your packet. Both Lisa and Kelly reviewed it. I looked at it as well. It's, as you'll see, it's pretty straightforward. But basically the idea is that, again, we're trying to get the organizational culture to be focused on protecting the personal information that we have as part of county business. So this just sets in motion basically what needs to be inventoried, and then how we protect that and how we destroy that information as well when we're able to, based on public records. So that's all I've got on that one. Any questions about that?
I didn't have any questions. Did you?
I didn't have any questions. I move to adopt resolution number 2020-22 as presented.
I second.
Okay, it's been moved and seconded that we adopt resolution number R 2020-22, a lot of twos in there, as presented. Is there further discussion? All those in favor?
Aye.
Any opposed? Motion carries. Okay, we will move on to 7.3, which is consider approval of resolution number R 2020-23, a resolution adopting a revised fiscal year 2020-2021 Sheriff's Office salary schedule. So we passed, I don't see the resolution in here. So we passed, as you recall, on July 1st, the salary schedules for our represented employees, non-represented elected officials, and the sheriff's office. And then Ellen always looks those over. Obviously, she's entering them in the system, and caught a typo in Chris's, in particular, in the emergency management coordinator's position. The reason for that is that we had actually moved Chris from 37.5 hours up to 40. And so when we were recalculating that, we missed it. So basically the resolution would correct the error and make sure that she gets the full 2.5% COLA that she's due.
Housekeeping.
Basically housekeeping, yeah.
Any comment, Commissioner Weatherall?
So she wasn't willing to go ahead and work 40 hours for only 37.5 pay?
She declined that opportunity.
I didn't have any questions.
I think she's been working 45 to 50 hours. To be honest.
Oh, I bet.
Well, I move to adopt resolution number R 2020-23 as presented.
Second.
It's been moved and seconded that we adopt resolution number R 2020-23 as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, moving on here. We are almost through with the agenda. 7.4 is discuss modification of Gillum County Historical Society Special Project Grant Award. This is another housekeeping item. The Historical Society reached out. They were a recipient of a special projects grant from last year. You probably remember they're constructing a new exhibit building up there. Obviously with COVID and everything else that's happening, their construction timeline has been extended into the upcoming fiscal year. And the grant agreements say that it has to be extended in last year. So they are just wanting to know if we can amend that grant agreement, giving them that extra year so that they can basically finish the building and all that kind of stuff. So I'm just looking for approval from you guys to go ahead and amend that, give them that additional year, and then Teresa and I will get them a new amended grant agreement to clean that up.
Yes. Yes.
Sherry's on board. Are you on board? Okay. Do we have a motion?
It's her turn.
Sherry says it's your turn, Leslie.
I heard that. Okay, I move to amend the fiscal year 2019-2020 Special Projects Grant Award to the Gillum County Historical Society for construction of a new exhibit building by extending the deadline for expending the grant funds to June 30, 2021, and to authorize the county judge to prepare and execute an amended grant agreement reflecting the same.
I second.
Okay, it's been moved and seconded that we amend the fiscal year 2019-2020 Special Projects Grant Award to the Gillum County Historical Society for construction of a new exhibit building by extending the deadline for expending the grant funds to June 30th, 2021, to authorize the county judge to prepare and execute an amended grant agreement reflecting the same. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? The motion carries. Okay, we're still waiting on Michelle to come back for 7.5, which is the conditional use permit.
She's just printing.
So why don't we do announcements and talk about next meeting? And then, and that way, Leslie as well, because you'll have to recuse yourself from that. That way you can hop off after we're done. So how about announcements? And next meeting is scheduled for August 5th. Question I have for the commissioners, do you guys want to meet in person? We can do it here as we did today, or do you want to move them back to Zoom?
I'd like to move back to Zoom.
Okay. Leslie, what do you think?
I agree.
Okay, so we will plan on for the August 5th meeting that will be conducted over Zoom. And we'll just kind of play it by ear and see what happens with this virus situation to see how long that lasts. Other announcements for the group.
I'm gonna go first. We did not have a Norcore board meeting in June, because there just wasn't enough. I don't know if I told you that last meeting or not. We didn't have enough for an agenda, so we postponed to this month. I haven't heard yet what we're doing. I will be Zoom attending the Cape Coast meeting on Friday, this coming Friday at 11. So I've been asked to participate, and I will be doing that.
Great. What about you, Leslie? What's going on in your neck of the woods?
I don't, well, I did attend a North Central Public Health District meeting during the break between the last time we met. They did tell us that Wasco County had been moved to the watch list because of the number of cases they were having. Last week at the meeting, they did report that Wasco County was up to 119 positive cases, Gillum County 2, Sherman County 5. That's probably changed between now and then. We're still proceeding with trying to hire a new director, and that's about it. Did we find out what's going to happen with the Tri-County court meeting or Tri-County meeting?
Nobody had any agenda items because I think everybody's just doing COVID and there's not a lot of activity. So we decided to go ahead and postpone that until October would be when the next quarterly meeting comes up. So I guess we'll just kind of play it by ear and see how long we're doing this for. The other things I had were the Frontier Telenet Board has a Zoom meeting next Friday. So we will hopefully be getting bids back for the Roosevelt site to fix the roof and the electrical. I think that's the only, let me just look at my.
And I believe Commissioner Weatherall also met with Arlington School Superintendent Brandon Hammond at his invitation, and that was interesting. He's very gung ho, and a lot of things happening at the school. It was nice to meet him. I actually hadn't met him previously, but it was nice to sit down and talk about school and not whether he was going to build a house or not.
Yeah, I had a good meeting with him as well. And you had one as well, Leslie?
I did. I was glad that he had reached out and extended that invitation. I even got a little tour of I didn't need much of a tour of the school, but of their that big building they have out back. I can't remember what the initials of it are, but it was pretty impressive.
Yeah.
They're doing a lot of good things there in that part of their curriculum.
Mm-hmm.
They want to expand it. I'd like to see them. One of the things I did talk to him about, and I think Leslie did as well, was our communication between the two schools in the county and working more closely together and sharing curriculum and being a little more cohesive.
Yeah. One of the things I talked to him about related, I think, to both your point and the CTE that Leslie brought up was Sherry and I, when we were at County College, we went to Salem Kaiser School District that had a very impressive sort of alternative path for kids who were more interested in the trades. And so that's something that I talked to Brandon about, and I think he has a strong interest in, and maybe looking at a tri-county partnership with Morrow and Sherman County to see if maybe there's a way we could replicate that for our students here. So he was excited about that. So I'm hoping once we're able to travel and meet in person more, we had talked about maybe setting up a tour of that school at Salem Kaiser. So that our
amazing.
all of the local superintendents could see what that looks like and how they It was neat because the students were still part of their home school district. So if kids wanted to participate, say in a construction trades program, then maybe on Tuesdays and Thursdays they'd go to Arlington to do construction trades, but they're still counted as Condon kids. So you're not losing enrollment that way. But it was a cool, very neat program and very dynamic superintendent at that school. So Brandon and I had talked about maybe setting up something to go actually see so people could see what that program looks like. And so
It was
we could-
amazing the different, they had culinary and hair design and welding and building and they just covered so many different aspects. It was great.
Yeah, it
Kids
was
could come out of that and have a certificate to move on
mhm.
in the world.
Yeah.
Yes.
So I am excited about that. And he had
Yes.
brought it up first. I tried to stay in my lane, but he brought it up first. So I thought I would love to partner with something on that. It was a very cool thing. So, so anyway, and I think those are the only upcoming meetings we have. Obviously, August 5th will be our next regular meeting for us. So I'm thinking while we're waiting for Michelle to come down that we'll probably just recess. And then I don't know, Leslie, if you want to stay on or if you want to hop off since you're going to just have to recuse yourself anyway. Up to you. Let us know what you prefer.
Do you anticipate well, I guess you probably don't know. I was wondering how much of a conversation there might be, or is it just going to be a pretty quick approval?
I mean, I'm thinking that we probably already had the bulk of the conversation, so it's just going to be reviewing the draft to make sure all the changes got put in it and probably just a motion. So
Our only guests remaining are our waste management representatives.
yeah, so I'm thinking it'll be pretty quick. But Michelle's on her way back from the courthouse, so we'll probably just, it's 12:41, so let's just take a quick break, and then when Michelle comes in, we can resume and go and tackle 7.5 on the agenda. Are we recording again?
We are recording again.
Okay, so it is 12:45 and I will be back in session. And so we are just wrapping up agenda item 7.5, which is consider approval of order number 2020-01, modifications to conditions of approval, conditional use permit 2020-01 for waste management, disposal services of Oregon for Columbia Ridge Landfill and Recycling Center.
Oh boy, another version.
Another version.
It's quite a file now.
I think should we just walk through and make sure everything
Real
got in
quick.
here?
Yeah, let me get my version that has all my little notes on it and we'll see how we did. All right.
So condition number 1, in the first sentence up there, it now says on or before December 31st, 2025, and every 5 years thereafter, the conditional use permit must be reviewed at a public hearing before the county court. The county court, after recommendation by the planning commission, may reapprove the conditional use permit after considering the following.
Perfect.
Then nothing has changed until you get to the very last sentence of that last paragraph. And it says, alternatively, if the county court finds that A, B, C, and or D, or A, B, and or C are not satisfied, the county court may impose additional conditions. So we've added county court reference twice in that last sentence.
Okay,
Great.
Okay. Number 2, there were no changes.
right.
Number 3, I added an E to preemption, and we added the word county court
Instead of planning.
instead of planning commission.
Perfect.
Number 4, there were no changes. I added back in number 5, the disqualification, and so that was just the language that was proposed.
Right.
Okay.
Good.
Number 6, there were no changes. Number 7, we inserted the words at the very end of that to county court rather than planning department.
Oh, right, okay.
Number 8, we added number 8 back in. And then, so number 9, we put in recycling. So I added the ing to the A there.
All right.
Got that?
That was missing.
Nice work, Michelle.
Okay, so number 10. Yes, number 10. So it is the last sentence there that we're adding to what was already there. Notwithstanding anything herein to the contrary, all vehicles, trailers, and other forms of transportation utilizing public roadways must be covered on both inbound and outbound trips to the site. Hopefully that works.
Perfect.
I
What do you
think
think?
I think it's good.
I think that's
Yeah, I love it.
fantastic.
Okay, so then number 11 doesn't change. Well, we just took out the, no, 11's fine.
No,
12's
okay,
fine.
yeah.
13.
Oh,
And
wait a
so,
minute, yeah, number 11, we took out the word any solid wastes in that,
Yeah.
down there, right?
Which you did.
yes, I
Yeah, no,
took it out, I just can't find it.
I can't either.
It's out.
There it is. I
It's
see it.
out.
I see it, it's gone.
It's official.
There you
It's
go.
on.
Yeah, so the beginning of the last sentence where it says any
Right.
waste, there was a qualifier, and we took out the qualifier on number 11. So then we go to number 12, no changes on 12.
Right,
Then we go to 13, which is our litter control now.
right,
No changes there. 14, visibility, no changes. 15, no changes, which is the rail.
right,
16 is our new addition of technology and practices, no changes. And then 17 now is the facility site plan, master plan, no changes.
Great. Looks fantastic. So Michelle, I have a question on the motion. Does this count then as the exhibit or?
So I don't know how that motion works, but you need to, somehow the court needs to acknowledge you have amended the exhibit A to the court order. And
Okay,
so we just went through all of those amendments to exhibit A, and so what you will be adopting is now the amended exhibit to the court order.
okay.
okay.
So we need the second
So
sample
we
language.
need I move to approve court order number 2020-01 with exhibit A as amended.
As
Isn't there
amended.
exhibit B as well?
So exhibit A is the conditions, but the conditions themselves refer to that
Oh,
site plan
okay.
and the litter control, because that's all part of all these conditions. Yeah, that was in your packet.
Again, I move to approve court order number 2020-01 with exhibit A as amended.
I'll second it. It's been moved and seconded that we approve court order number 2020-01 with exhibit A as amended. Is there further discussion? I should note too for the record that, that Commissioner Weatherall stepped off since she recused herself and so that's why she's not voting on this. All those in favor?
Aye.
Aye. Any opposed? Motion carries. All right, it's done. Congratulations,
All your
guys.
hard work.
I'll give you a hug, but we can't.
Cheering and cheering. Well, the year's over, we can cheer now.
Thank you very much, everybody. Everybody worked so hard on this.
And when they sign up, we'll get you the signed copy too.
Yeah, that would be awesome.
When you get a chance, come
Yeah, I'll
on,
take
and I'll show you the site.
Yeah, all of you. Feel free anytime to come and visit. We'll give you tours.
Thank you so much.
So is there
We need
any
to do that.
more business before the board?
Thank you.
If not,
Thanks,
it is
Bye,
12:51.
thanks for coming.
It's 12:51 and I'll adjourn the meeting.